All right, let's dive right into this explainer and demystify one of the most powerful legal tools that businesses use to protect their commercial interests in India. Look, disputes are a totally normal part of business life, right? But how you actually handle them, well, that can make or break your company's future. So today we're unpacking the India Arbitration and Conciliation Act 1996. It's essentially the primary law that gives you a faster, private, and enforceable way to settle conflicts.
We have to start with the ultimate problem for literally any business out there. The traditional court system is notoriously slow. You could be stuck in litigation for years, sometimes decades, honestly, just watching your resources and your reputation get dragged through the mud. And if you're a business owner, you simply don't have that kind of time. You need a fast, enforceable alternative. And that is exactly why this specific act exists.
So here is our roadmap for the explainer. We're breaking this down into 5 parts. 1. Why arbitration beats litigation. 2. Decoding the 1996 Act. 3. The 6-step arbitration process. 4. Evolution and key amendments. And finally, 5. Drafting bulletproof arbitration clauses.
Okay, Section 1. Why arbitration beats litigation. Fast-tracking dispute resolution.
Think about the stark contrast between traditional courts and arbitration for a second. In litigation, your dirty laundry is basically aired out in public court records. But in arbitration, the proceedings usually remain strictly confidential, which is absolutely crucial for protecting your trade secrets. Plus, courts suffer from those lengthy delays and generalist judges we talked about. I mean, do you really want a judge who handled a local traffic dispute this morning deciding the fate of your complex tech contract this afternoon? Probably not. Arbitration actually lets you choose industry experts, set strict statutory timelines, and completely bypass rigid procedural rules. You get incredible flexibility to choose the timeline, the language, and even the location.
Now, I want you to focus on this number, 160. Because India is a signatory to the New York Convention, an arbitral award that you win under this act is legally enforceable in over 160 countries globally. That's huge. You aren't just winning a localized piece of paper, you're winning a globally recognized decree. For export-oriented and multinational businesses, this global enforceability is what makes arbitration a real game changer.
Moving right along to Section 2, Decoding the 1996 Act, Structure and Scope. So the crucial point to understand here is that Parliament enacted this consolidated statute to completely modernize India's legal framework. Because before 1996, arbitration in India suffered from, well, excessive court interference. Judges were constantly stepping in and delaying things. By replacing 3 outdated laws and aligning directly with the UN's Citral Model Law on international commercial arbitration, India dramatically minimized judicial intervention. This one move totally transformed India's reputation as a reliable, pro-business destination for dispute resolution.
Now, it's worth noting the Act covers both arbitration and conciliation, and it's vital we define conciliation early on. Governed by Part 3 of the Act, conciliation is a voluntary, non-adjudicatory process. A conciliator doesn't decide the dispute like an arbitrator does. Instead, they facilitate dialogue to help both parties find common ground. Because it relies on cooperation rather than confrontation, it's a fantastic way to preserve those long-term business relationships. Plus, if you do actually reach a settlement, Section 74 gives it the exact same enforceable status as an arbitral award.
There is also a critical distinction within the Act that you absolutely need to know: domestic versus international commercial arbitration. Domestic, which is governed by Part 1, involves Indian parties resolving disputes within India. But if your dispute involves at least one foreign party, it instantly becomes international commercial arbitration under Section 21F. The key takeaway here: even when these international cases are seated in India, they get an extra layer of judicial expertise, because higher courts typically step in to handle their related applications.
Okay, let's simplify a very common piece of legal jargon that honestly trips up a lot of businesses: the difference between the seat and the venue. The venue, that's just the physical room where you meet to argue the case. But the seat is the legal home of the arbitration. It dictates which country's courts hold supervisory jurisdiction over your dispute. Getting this wrong in a cross-border contract can lead to massive, and I mean massive, jurisdictional headaches down the line.
Let's move into Section 3, the 6-step arbitration process. From agreement to award.
Let's actually track how a conflict moves from a simple contract clause all the way to a binding decision. It starts with Step 1, having a valid written arbitration agreement. Step 2 is appointing your arbitrators. Step 3 involves preliminary hearings where you set your procedural timetable. In Step 4, the claimant files their formal claim and the respondent answers. Step 5 is really the meat of the process.
submitting documents, expert reports, and doing cross-examinations, but with far less rigidity than a formal court trial. And finally, step 6, the tribunal issues a reasoned written arbitral award.
What you should really take away from this is that once you reach that final step and get the award, it has serious teeth. It carries the exact same legal force as a civil court decree. You can't just appeal it because you don't like the decision. Under Section 34, an award can only be challenged on incredibly narrow procedural grounds, things like an invalid agreement or a direct conflict with India's public policy. Courts apply these grounds very strictly, meaning losing parties can't just drag disputes through endless, exhausting appeals.
Next up, Section 4, Evolution and Key Amendments, keeping the law relevant.
Tracking these major legislative amendments is fascinating because it shows Parliament's commitment to making this system virtually airtight. The 2015 amendment was a total game changer. It introduced a strict 12-month timeline for tribunals to issue awards, and it implemented a cost-following-the-event principle. Basically, that forces the losing party to pay the winner's costs, which heavily discourages frivolous claims. Then the 2019 amendment created the Arbitration Council of India to push for more professional institutional arbitration. And in 2021, they allowed unconditional stays on enforcement if the underlying agreement involved fraud or corruption.
This quote perfectly captures the core philosophy of Section 8 of the Act. Think about it. If one party tries to sneakily file a lawsuit in civil court when an arbitration agreement already exists, Section 8 requires the court to refer them straight back to arbitration. The court applies what's called a prima facie review. That just means they do a surface-level check to ensure a valid agreement exists. The overriding message here is loud and clear: minimal judicial interference.
Finally, let's wrap up with Section 5, Drafting Bulletproof Arbitration Clauses, your practical action plan.
If you're drafting a contract today, use this exact checklist to prevent a future procedural nightmare. First off, specify the seat explicitly. Lock down exactly which courts have supervisory power. Second, choose your number of arbitrators. A sole arbitrator is definitely cheaper, while a 3-member panel offers broader expertise. Third, select institutional rules instead of just making it up ad hoc. This gives you real procedural certainty. And finally, lock down the language, the venue, and the governing law. A vague, poorly drafted clause will completely undermine the benefits of this entire act.
Now, a crucial piece of advice for anyone using this framework is that this fast-track system absolutely requires you to act quickly. Whether you're seeking interim relief to protect assets under Section 9, initiating the arbitration itself, or challenging an award, you are bound by strict limitation periods. If you sleep on your rights, you risk losing your legal remedies entirely.
So, we'll leave you with this provocative question to think about. The 1996 Act is an incredibly powerful tool, beautifully balancing party autonomy with judicial oversight, but it only works if you set it up correctly in your contracts. Take the time today to audit your existing agreements. Make sure you are truly prepared to leverage this incredible dispute resolution framework when a conflict inevitably arises. Thanks for joining us for this explainer, and we'll see you next time.